Hello and welcome to Uncommon Law, my podcast about true stories from my life experience of over 50 years as a lawyer and trial judge. This is a look at the law from the inside out, stuff they don't teach in law school. This is Judge Rudy Greco, retired justice of the New York State Supreme Court. Every October, the United States Supreme Court, or Supreme Court of the United States, or S.C.O.T.U.S. as the acronym has become popular in use, convenes, and the newspapers are replete with stories about all the issues that the court will be facing, and the important issues they'll be facing in the coming session from October through June, when they start rendering decisions on those issues. And that always brings to mind, every year when I read those articles, I recall my own experience as an attorney that appeared before the United States Supreme Court. Well, when I finally passed the bar, after 8 years after I was thrown out of St. John's Law School unceremoniously, I joined up with my friend from college, Joe Feraldo, who was in private practice. Joe and I, in a small partnership, everybody does the work. It's just the two of us, and trying to pay the rent, and we're both young guys. And Joe had a family. Most of his uncles and his cousins were all named Joseph Feraldo because the dean of the family was his grandfather, Joe Feraldo, insisted that everybody name their firstborn Joe Feraldo after him, naturally. He presided over a scrap iron business on Kingsland Avenue in Williamsburg. And that's where Joe came from. He came from North Brooklyn, Williamsburg. And I came from South Brooklyn, Red Hook. But we met in college, and we're two Brooklyn guys, and we hit it off despite the North-South divide in Brooklyn. And we became longtime friends. Joe was actually a chemistry major. I was a political science major. And he blames his deviation from chemistry to the law on me, and I take no responsibility for that. He's a strong-minded guy, and he made up his mind. Somewhere along the line, he decided to become a lawyer, and that was to my benefit because he was a great partner and a good guy, and he's still my friend after 50 years, or 60 years now, almost. Joe's uncle, Dr. Joseph Feraldo, was a local hero and a notable character in Williamsburg. He was everybody's family doctor. He also owned 20 or so harness racing horses, trotters and pacers. And the doctor's son was also named Joseph Feraldo, probably the third or the fourth or whatever. And cousin Joe was a driver. He used to drive his father's horses at the races. And where did they race? They raced at Yonkers, and they raced at Roosevelt Raceway. Yonkers was just outside the city, north of the city in Westchester County. And Roosevelt Raceway was in Nassau County, just outside the city. And it was founded by a guy named George Morton Levy. George Morton Levy himself was a fascinating story, because he was a trial lawyer, a defense lawyer, had won many, many murder cases. His office was in Freeport in Nassau County, and he won a lot of murder cases. He was a very clever guy, a little diminutive guy, very smart. And in the 1930s, going into the 1940s, just after the war, he figured out that harness racing would be good. People had come home from the war. People were prosperous. Everybody was working. People looking for diversion and recreation. And he envisioned a big audience for what was traditionally a county fair sport, a county fair thing, harness racing. It was a very ex-urban kind of a thing. Farmers and people raced their horses, and trotters and pacers. And George went out and begged, borrowed, and stole all the money he could from all the friends he could. And he built Roosevelt Raceway. Roosevelt Raceway was George Morton Levy's baby, and it was a raging success. He had night racing under the lights, where all working people could come after work and gamble on the horse racing and have a good time and have restaurants and drinks and bars, etc., etc. And it was a raging success for many, many, many years. And now it's just a big shopping center because he sold off when George died, and the business started to tail off because of television and everything else. But George Morton Levy was a brilliant guy. In fact, I was in a negotiation with him once over a business contract, and I said, Mr. Levy, I want you to know, he was in his 80s at the time. I said, I want you to know that my client is personally guaranteeing this contract and the performance of this contract. He's personally taking responsibility. And Mr. Levy looked at me, he said, you're a young fella, and I want you to listen to what I'm going to tell you right now and never forget it. A guarantee only as good as the guarantor. And he was 100% right, and I carried that with me all through my legal career and all my life. He's 100% right. A guarantee, yeah, wonderful. But how's the guarantor? That's the thing that counts. In any event, because of the Feraldo family involvement in harness racing, Joe was referred a steady stream of business from the harness racing people. Trainers, drivers, owners, officials at the racetrack, etc., etc. And one of them that came to our office was a guy named John Barchi. John Barchi was a young man who grew up in Westbury, right near the racetrack, Roosevelt Raceway. His family owned a beautiful restaurant, which was a big hangout for all the racing people. It was an Italian restaurant, really nice family-run place, and it was a very pleasant place to be in. It was almost unofficial headquarters after the races or before the races, where all the racing people would wine and dine, and the whole industry met there. Well, John Barchi trained horses. He trained harness horses. He grew up next to the track, and that was his ambition. And he was good. He was an up-and-coming young guy, a very nice guy, hardworking, middle-class guy. And then comes a problem. One of John's horses tested positive for a performance-enhancing drug. And it was a problem because under the New York State Racing and Wagering Board rules and regulations, the trainer of a horse, the named trainer of a horse, is the insurer of that horse's condition. In other words, anything wrong with that horse, it's the trainer's fault. Period. No questions asked. John's horse came up positive, as I say, for a prohibited substance, but John himself, when this was administered and when this happened, had been in Florida for days before this happened, when this happened, the day that it happened, and days afterwards. He was down there on horse business doing something else. He was nowhere within 1,500 miles of the racetrack when this happened. And track security is a big show about track security, but it's pretty lax. Once you get past the gate, and you can get past the gates and guards and everything else pretty easily, anything could happen. Anybody could run into anybody else's barn and inject a horse with a substance without that owner or trainer even knowing about it, or the hands, the trained hands, even knowing about it. And if the horse tests positive, that trainer is the insurer. He's going to get the penalty. The Racing and Wagering Board brought John up on charges. He took 3 polygraph exams, lie detector tests. One was before our own expert that we picked, Joe and I, a guy named Victor Kaufman, an ex-detective, very famous detective in New York City who was in the polygraph business when he retired. Another one was selected by the state, one of their official employees. And another one was a totally independent one that we both sides agreed on. And John passed every one of those polygraph tests with flying colors. There was no problem. He had nothing to do with this incident and this horse being drugged. He was totally innocent. However, that didn't matter. They suspended John Barchi. But wait, there's more. Not only did they suspend him, but they suspended him without a hearing. He had no hearing. And they simply suspended him. And that we apparently understood right away. It was a blatant violation of the Sixth Amendment prohibition against deprivation of due process. You can't take somebody's life, liberty, or happiness away without due process. And life, liberty, and happiness is your job. Is the main factor in your life, liberty, your job, and your health, and your liberty. Your freedom. So the State Racing and Wagering Board wouldn't hear it, and I had an incident where the state investigator was a guy named Danny Goldberg, who was a decent guy, and I said, Danny, this is ridiculous. And I know John Barchi had nothing to do with this, and here he is, he's getting suspended. And he didn't even have a hearing. He said, well, that's the way we've been doing this for 42 years. I said, but doesn't that strike you as the wrong thing? He said, well, I'm just taking orders. I said, Danny, coming from you, that doesn't sound so good. Just taking orders. A lot of people said after World War II they were just taking orders, and it wasn't nice. And it wasn't acceptable. And I don't think it's acceptable. So we're going to go and we're going to appeal this case. He said, well, we never changed this law, and we've been doing this for 42 years. You're not going to change the law. Now I says, well, you watch, because we're going to change this law. This is an outright deprivation of due process. So Joe and I, being a two-man law firm, we had we were both involved in each other's work. I did most of the criminal work. He did most of the horse racing. We both did commercial work and closings and wills and the bread and butter stuff. It was just whatever came up, we just divided it in half. And immediately we went and petitioned at the United States District Court for the Southern District of New York for a 3-judge constitutional court. This was 1 week. This is in August 1978, probably 1 week before that law and that procedure expired. It was invalidated after that. They didn't want to do it anymore. We asked a Judge Robert Sweet, made our arguments, said the state law is unconstitutional. We want to get a 3-judge constitutional court to hear about the constitutionality and declare the constitutionality of that law, whether it is or it isn't constitutional. Judge Sweet granted our petition. 2 or 3 days later, immediately, the United States Circuit Court of Appeals for the Second Circuit, which is New York, includes New York and Connecticut and a couple of other states, or New Jersey, they convened a 3-judge constitutional court. The state sent an assistant attorney general to argue the state's case, and we argued on John Barchi's behalf. And sure enough, we got a favorable decision saying, in effect, in no uncertain terms, the New York state law that permits suspensions without hearings is unconstitutional. It's unconstitutional. Well, we were happy. The state was just as unhappy as we were happy. And the state, because of the declaration of unconstitutionality of its law, just like any state whose law is declared unconstitutional, has a direct right of appeal directly to the Supreme Court of the United States. So here we go. Now, that time we had another case in the Court of Appeals, a criminal case, a criminal usury case. And the Court of Appeals is the highest court in the state of New York, and the Supreme Court of the United States is the highest court in the federal system. And here we are, 2 young guys with middle-class clients with no money, little money, and we have these 2 giant cases, which are the chance of a lifetime to make law. Lawyers would die to have these chances to make law and get these big cases if they had the appetite to take them on, because it's a big job. We divided the responsibility. I took the main responsibility for the Court of Appeals cases with the usury, which is a criminal one in nature, and Joe took the main responsibility for the racing case going to the Supreme Court of the United States, because he did most of the racing work, and he was active also with his family in harness racing, and he got the case. And we split the responsibility. However, both of us worked on the other guy's case, because we're only 2 guys in a small law office, and these are big jobs. That took up a whole year. To get 2 of them at once simultaneously was unheard of. And here we had, two big cases of a lifetime coming at the same time. We both came to Washington, D.C., for the big day at the Supreme Court of the United States when John Bocce's case was going to be heard by the highest court in the land. We took the shuttle down to Washington early in the morning. We got to the court early, and we were in the court cafeteria looking around when this little old gentleman came up and said, I don't recognize you young fellas. I've never seen you before up here. And my guess is that this is your first time here. And we said, yeah, actually it is. You're right. And he said, well, go for the muffins in this cafeteria. They're homemade. You want to have those muffins. He said, they're really good. That's my recommendation. And we thanked him. And that was Justice Harry Blackmun of the Supreme Court of the United States who was recommending the muffins. So we followed his suggestion, and they were good. They were really good. Well, coffee, muffins are over, and time comes to go upstairs to the big room where the court sits. And when you get to the doorway, it's very, very impressive, very imposing. A lot of mahogany, a lot of marble, a lot of polished brass, a lot of flags, big velvet curtain all the way at the back of the raised stage, as it were, and all the seats filled with spectators from all over the country and lawyers. And you have to be escorted. Everybody has assigned seats, not the tourists. They get herded into a certain section. But the lawyers all have assigned seats. The court has a full calendar, and it's very highly and well organized. And the clerk of the court, himself a pretty impressive figure. Why? He's dressed in a morning coat, tails, and striped pants, and a white starched shirt front, and a bow tie, etc. And he's ready to escort us. And he said, listen, fellas, if your knees are knocking, don't worry. Bobby Kennedy comes here as the Attorney General of the United States, and every time he comes here, his knees are knocking. No big thing. I said, excuse me. We're two dopes from Brooklyn. We're too stupid to be scared here. Just show us where we sit. Well, he had a laugh, and we all had a laugh, and that took some of the tension out of it. Because the fact of the matter is we were scared. And he escorted us to our assigned seats right up front, right in front of the bench. I think we were maybe in the second row, perhaps. There were lawyers, there was a docket of maybe 8 or 10 cases on that day, and there were lawyers all over the place. And we showed up armed with briefs from all over the country. We had horse racing organizations from Kentucky, California, and everybody where they had done the same thing. And they were all on our side saying, don't suspend people without hearings. It's a deprivation of due process. And they all do it. They all did it. It was really bad because in many cases we had briefs from horsemen who said they were suspended and then served the suspension 30, 60, 90 days, a year. And afterwards, there was a hearing at which they were exonerated. So this was Alice in Wonderland, and that's what we're talking about. This was an Alice in Wonderland proposition. First the execution, and then the trial. It's crazy. And we had affidavits from numerous horsemen who said after they were suspended and returned, even after exoneration, they took, in many cases, 10 years to get back to their financial status as it was prior to being suspended and then to equal their income. It was really damaging. It was nasty stuff. Well, the court comes out, and it's like a real theater. They come out from behind this giant burgundy velvet curtain, and all the justices emerge like the Wizard of Oz from behind the curtain, and they all take seats. And there's all of them across. And the chief judge was dead center, and that was Warren Burger. And the new guy on the court, the new kid on the court, was Justice Rehnquist, William Rehnquist from California, who later became the chief judge. And fittingly, he was as a junior man, he was on the far right wing, like a wide receiver on that line of a football team. And we made oral arguments. And by the way, when we got to our seat, I don't want to forget mentioning that a very nice gesture in the Supreme Court. All the lawyers are given souvenirs of the court. What are they? A little clear glass, tiny little inkwell with a quill pen. goose-feathered quill pen. And I still have mine home. And it's a nice little memento of the Supreme Court. So oral arguments took place, and the state, the attorney general, who was the lawyer for New York State, the name of the case was Barry v. Barchi, because John Barry became the commissioner of the New York State Racing and Wagering Board, and the case was brought in his name, and we were the appellees rather than the appellant. We were the winners who were taken by the losers to an appeal, which was a pleasant surprise. Because we already had a favorable decision in our repertoire, and the state got up and made the arguments, which were at that point in time pretty familiar and predictable. The state said Pari Mutual Racing is the biggest single taxpayer in New York State, and as such, the state has police power and has to maintain the integrity of racing so that the betting public can feel confident that the racing is not fixed and it's clean, and their wages are being made on level playing fields. And therefore, they need the immediate right to suspend licensees so that if there's any irregularity, the public gets the impression, the correct impression, that this is being policed promptly and justly and rapidly. Well, Joe made the usual arguments and saying you can't hang people and then try them later, or execute them and try them later, and this is a deprivation of due process because you're taking away guys' livelihoods, et cetera, et cetera. And then everybody was familiar with the arguments, and I think we had the better argument. And it was the new Judge Rehnquist, who basically saved the day in essence, because he got up and he asked a question. And Joe was the lead on this one. And he said, how would you feel if the state had an immediate right to suspend licensees for any violation, but had to conduct a hearing within 24 hours? Now, we had anticipated that query and any other question we could possibly think of, and Joe had a ready answer. And he said, Your Honor, we're not here to subvert the entire pari-mutuel betting industry, horse racing, whether it be thoroughbred or harness racing. Our people make a living racing horses, and we want the system to continue and to flourish, and we want it to be honest and open. We have no problem with a hearing that would take place within 24 hours. We have a problem when they don't have a hearing and they suspend people, and it's held after the sentence is carried out. And the court took a cue from Justice Rehnquist, and we got a favorable decision. It was slightly modified from the lower one, and said the state can do this and they can suspend people as long as they give us a hearing, give the suspended party a hearing within 24 hours. And that was a big, big victory. And Joe and I broke up eventually because we were doing different work. We started, as practices grew, I was doing more and more criminal work, and Joe was doing more and more racing work. In spite of the fact that we broke up our partnership, there was no malice or ill will. We were lifelong friends and remain lifelong friends to this day. And 5 years ago, 45 years after the Supreme Court decision, Joe got married, and I officiated at his wedding. 45 years later, I look back at my trip to the Supreme Court with great pride and satisfaction. The experience was truly memorable, especially the muffins. Thanks for listening. Come back next week for another episode of Uncommon Law, lessons they don't teach in law school. I'm Judge Rudy Greco. Court is adjourned.